Welcome to episode 50 on the law rapport. Today we are going to deal with divorce in the Turks and Caicos Islands, and we are going to look at the Matrimonial Causes Ordinance in the Turks and Caicos Islands. Unless parties are married for 3 years, there cannot be any petition for divorce except in exceptional circumstances. We'll be back to discuss that. Before I do, my usual disclaimer: this is not legal advice, should not be taken as legal advice. For legal advice, please contact an attorney of your choice. The law in relation to divorce in the Turks and Caicos Islands is found in the Matrimonial Causes Ordinance. Section 3 of the ordinance gives the court, and in this case the Supreme Court, jurisdiction to entertain proceedings for nullity of marriage, but only if A, either of the parties is domiciled in the islands and the date when the proceedings are begun, meaning that one of the parties must live or must reside in the Turks and Caicos Islands, even though a marriage may have been in another country. So you could get married outside of the Turks and Caicos Islands, but you could get divorced in the Turks and Caicos Islands if one or more of the parties is residing in the island at the time when the proceedings for the marriage began, or B, was ordinary resident in the islands throughout the period of 1 year ending with that date. That would be the date when the proceedings began. Now, there is one reason for the divorce to be granted in the Turks and Caicos Islands, and that is that the marriage must have broken down irretrievably. So, the overarching reason for a divorce in the Turks and Caicos Islands is that a court must find that the marriage has broken down irretrievably, that the marriage is over. It's done. However, in order to support this conclusion, there are 5 grounds that a party petitioning for divorce could rely on to convince or to satisfy the court that the marriage has indeed broken down irretrievably. One such ground, according to Section 5 of the Matrimonial Causes Ordinance, is that the respondent or the person who is responding to the petition filed by one party to the marriage, so the respondent has committed adultery, and in consequence of that adultery, the petitioner finds it intolerable to live with the respondents. And we know, for common expression, adultery is cheating. So if the party petitioning for the marriage is relying on this ground to show that the marriage has broken down irretrievably, that party must produce evidence so that the court could be satisfied that the marriage has indeed broken down. B, that the respondent has behaved in such a way that the petitioner cannot reasonably be expected to live with the respondent. And now this is a ground that offers flexibility to petitioners, because in my opinion, this ground could encompass abuse, may it be physical, mental, or verbal. And so a petitioner could rely on the behavior of the respondent to satisfy the court that the marriage has broken down irretrievably. C, that the respondent has deserted the petitioner for a continuous period of 2 years immediately preceding the presentation of the petition. So the party bringing the divorce proceedings can allege that the other party, the respondent in this case, has deserted them for a continuous period of 2 years. And a continuous period would be 2 years continually, consecutively, one after the other. And if the party bringing the divorce proceedings and satisfy the court that there was a 2-year desertion period, then this could form a ground in which the court could be satisfied that the marriage has broken down irretrievably. D, that the parties to the marriage has lived apart for a continuous period of at least 2 years immediately preceding the presentation of the petition. Here in this ordinance referred to as the 2 years of separation, and the respondent consents to the decree being granted. So if the party has lived apart for 2 years continually or continuous, and the respondent consents and said, yes, I agree that we have been living apart, then the court could then be satisfied that the marriage has broken down irretrievably and grant the divorce. And the final ground is that the parties to the marriage has lived apart for a continuous period of at least 5 years immediately preceding the presentation of the petition, here in the ordinance referred to as the 5 years of separation. So if the parties have lived apart continuously for a 5-year period, the petition can begin proceedings based on the 5-year separation. They do not need consent of the other party. And once this is proven, the court could then be satisfied that the marriage has broken down irretrievably and grant the divorce. Let's look at Section 5, subsection 3 of the Matrimonial Causes Ordinance. It states that on a petition for divorce, it shall be the duty of the court to inquire so far as it reasonably can into the facts alleged by the petitioner and into any facts alleged by the respondent. Subsection 4. If the court is satisfied on the evidence of any such fact as is mentioned in subsection 5, then, unless it is satisfied on all of the evidence that the marriage has broken down, it shall, subject to Section 7, 3, and 9, grant the divorce. So, Once the court, having inquired into the facts presented by the parties, the petitioner, on the grounds that he or she is relying on, and on the respondent and their response to the petition, and the court, having considered carefully the facts presented by the parties, having concluded that the marriage has broken down irretrievably, then the divorce will be granted. Now, according to Section 7 of the ordinance, it states that no petition for divorce shall be presented to the court before the expiration of the period of 3 years from the date of the marriage, here in this section referred to as the specified period. However, subsection 2 states that a judge of the court may, on an application, allow the presentation of a petition for divorce within the specified period on the ground that the case is one of exceptional hardship suffered by the petitioner, or of exceptional depravity on the part of the respondent. But in determining the application, the judge shall have regard to the interests of any child of the family, and to the question whether there is a reasonable probability of a reconciliation between the parties during the specified period. So there's an exception to the 3-year rule, but the court, in entertaining the presentation of the divorce, is directed by the ordinance to take into consideration the interests of any child of the family, and to direct its mind to whether or not the marriage could be saved, or in other words, whether there could be a reconciliation between the parties. Now, in the event that the court accepts, or the court is satisfied that the marriage has broken down irretrievably and grants the divorce, in the first instance, the court would grant what is called the decree nisi. And then, after a period of 6 weeks, commonly known as a cooling off period, the court will then grant the decree absolute. Until the decree absolute is granted, the parties are not formally divorced. In another episode, I will deal with property division and property settlement, or property adjustment, under the ordinance. Here is where I will leave it for today. I hope that you have gleaned something useful from this episode. If you do, and you have any questions, please leave it in the comment section below, and I will see you in another episode. Thank you for watching.